Good afternoon. It gives me immense pleasure to deliver and talk on the topic Clean Slate Principle under the Insolvency and Bankruptcy Code 2016. I'm grateful to IGNU and pleased to deliver this lecture representing Insolvency and Bankruptcy Board of India, which is a frontline regulator for the corporate insolvency resolution process and the liquidation process. I'll make an introduction first, and then talk. Then the then honorable finance minister, when he was introducing the insolvency and bankruptcy bill in the year 2016, and introducing it for the very first time before the parliament, he stated that unlike other insolvency laws, the Insolvency and Bankruptcy Code 2016 aims at loans restructuring in a very different manner. These were his words. There is a reset, and then after the reset, the company is competitive once again, and it goes forward and it becomes successful. That is what happens consistently in the United States. They go into bankruptcy, the liabilities are reset, they become competitive again, and then thereafter they do fine. With these words in mind, the Insolvency and Bankruptcy Code was enacted in the year 2016. And when this code was enacted and passed by the parliament, it wished to address the highly fragmented and delay-prone legal regime which was relating to the insolvency and stressed debt resolution in India. As people are aware, the banking sector has been prone to high NPAs, non-performance accounts, and the bad loans, as it is commonly known. So the Insolvency and Bankruptcy Code that was brought about, it emerged as a comprehensive legislation for the insolvency resolution of Indian companies, limited liability partnership firms, and bankruptcy of individuals. Why do we say this is a comprehensive legislation? Because it is an all-encompassing legislation which covers all the entities, including companies, partnership firms, and individuals. Now, part 2 of the code deals with the insolvency and of the insolvency of the corporate persons, and you read it along with the Insolvency and Bankruptcy Board of India Insolvency Resolution for Corporate Person Regulations, which is more commonly known as the CRP regulations, which governs the conduct of insolvency resolution processes of the corporate debtor. Now, when I say CD, I mean a corporate debtor. What is a corporate debtor? A corporate debtor is basically an entity which has gone into corporate insolvency. Now, how does this process work? So, before starting on my topic, I'll tell a little briefly of how this process works. An insolvency resolution process can be initiated for payments of defaults. Currently, the minimum default that is there under the IBC is 1 crore, and after which, for the payment of default, an operational creditor, a financial creditor, or the corporate debtor himself can file an application before NCLT, which are the National Company Law Tribunals, and they are also known as adjudicating authorities under the Insolvency and Bankruptcy Code 2016. The NCLT hears the application, and thereafter, if it is satisfied that there is a default, makes an admission. After the admission, it admits the corporate insolvency resolution process and appoints an insolvency professional. This insolvency professional is regulated by the Insolvency and Bankruptcy Board of India, and this insolvency professional first acts as an IRP, then an RP, and if the resolution of the company fails, then also as a liquidator for the corporate debtor, which could be the corporate entity that has gone into corporate insolvency. The date of admission is the date on which the corporate insolvency resolution process for the corporate debtor commences. Now, what happens on this date? On this date, the NCLT, or the National Company Law Tribunal, along with the order of admission, issues an order of moratorium Now, what is a moratorium? A moratorium is issued, which basically means that during this period when the corporate insolvency resolution process is going on, no judicial proceedings for recovery, enforcement of security interest, sale or transfer of assets of the corporate debtor, or termination of essential contracts can be instituted or continued against the corporate debtor. So when this code was brought into being in the year 2016, the government knew that there was a big NPA problem, and when the corporate insolvency resolution process was going on, they understood that a concept like moratorium was needed to protect the corporate debtor from getting into further legal troubles, institution of legal proceedings when the whole corporate insolvency resolution process was going on. Now, what happens after the process of corporate insolvency starts? The IP, or the insolvency professional, also known as the resolution professional during this period, he invites resolution plans. Now, what are these resolution plans? These resolution plans are basically offers that are made by certain companies, group of persons, and these resolution plans are put forward by these companies or persons, which are otherwise commonly known as the resolution applicants. What happens after these resolution plans is these resolution plans are voted upon by the committee of creditors. These committee of creditors are the banks and other financial institutions, or basically the financial creditors of the corporate debtor. They look into the viability and feasibility of the resolution plan, and if they find this suitable with the requisite majority, that is 66%, vote for approval of the resolution plan. With the resolution plan being approved, the resolution applicant or the entity which wanted to buy or purchase or take over the CD which was under corporate insolvency takes over the entity. That taking over process only happens when, after approval of COC, the resolution plan is filed by the insolvency professional before the National Company Law Tribunal or the adjudicating authority, and the NCLT, when it is approved, becomes binding on all the stakeholders which are involved in the resolution plan. The code emphasized on rescue or resolution of a corporate debtor. So it wanted to save a company rather than liquidate it. These were the basic tenets or objectives of IBC, and this was the basic process of what happens in the Insolvency and Bankruptcy Code 2016. Now, my topic today is Section 32A. Section 32A was not there in the original code. It was introduced in the code by making an amendment in the year 2019. What are the legal provisions that are there in the code? I'll make a bare reading. Section 32A basically states that what happens to liability for prior offenses, etc. Now, the liability of a corporate debtor. The corporate debtor is the entity, as I said earlier, which is undergoing a corporate insolvency resolution process. So, its liability for an offense which was committed prior to the commencement of the corporate insolvency resolution process. So, this offense was committed prior to the admission that was made by the adjudicating authority. Now, this liability shall cease, means it shall not be there, it shall terminate and end, and the corporate debtor shall not be prosecuted. Prosecuted is a legal term. It means to prosecute someone in a court of law for an offense which involves a criminal liability. Now, this corporate debtor shall not be prosecuted for such an offense from the date the resolution plan has been approved by the adjudicating authority. Now, this resolution plan must have been approved by the adjudicating authority, which are the National Company Law Tribunals that have been set up by the Government of India, and it provides an immunity for such offenses that were committed prior to the corporate insolvency resolution process. There are certain provisions wherein this section 32A shall not apply. What are those? So it states that provided that the resolution plan results in the change or in the management or control of the corporate debtor to a person who was not. So one of the key criterias when a section 32A would be applicable is that a resolution plan which is approved by the adjudicating authority should result in the change in management or control of the corporate debtor, and that change in management or control of the corporate debtor must be to a person who is not, it says a promoter. He must not be a promoter of the corporate debtor of that company. He must not be one of the promoters, or in the management or control of the CD. So he must not be in management. He must not be a person who is in the management or control of the corporate debtor. He must not have a substantive interest of the corporate debtor. He must not have a pervasive interest of the corporate debtor. He must not make decisions on behalf of the corporate debtor. Or that person must not be a related party of such a person. The code also defines who can be a related party of such a person. There's a long list of definition. It also includes the relatives of such person. B of section 32A 1B says a person with regard to whom the relevant investigating authority has submitted a report or filed a complaint. So this section is not applicable where the relevant investigative authority, this investigative authority is the authority which is investigating the criminal offense that is being dealt, has submitted a report or filed a complaint, then it will not be applicable on them. And the second thing is, if a prosecution is instituted during CRP against such CD. So 32A, as it begins, it talks about offenses that have been, it states that for those offenses which are committed prior to the commencement of CRP, but what happens when the whole corporate insolvency process is going on, then if a prosecution is instituted by an investigating authority during CRP, which is the corporate insolvency resolution process, against such corporate debtor, which is the corporate entity, then it basically states that it shall stand discharged, means the liability or the investigating authority investigation shall not be continued from the date of approval of resolution plan by the adjudicating authority. The clause 3 of section 32A states that notwithstanding that the liability of corporate debtor, every person who was firstly, a designated partner under the Limited Liability Partnership Act 2008, or an officer in default, which is as defined under the Companies Act 2013, or any other person who is in charge of or responsible to the CD for the conduct of its business or associated with the CD in any manner, shall continue to be liable to be prosecuted and punished for such offence committed by the CD. Thus, the section 32A grants immunity to the corporate debtor or the corporate entity, which we understand is a separate legal entity from those persons as is mentioned under clause 3 of section 32A. But so this immunity is solely applicable to the corporate debtor and not to the above mentioned persons. However, it says that despite that liability of the corporate debtor has ceased or it does not continue to exist, the corporate debtor, and by corporate debtor we use the word corporate debtor as a legal entity of a corporate debtor. So all the persons who are in charge and in control or in management of the corporate debtor, they shall extend all assistance and cooperation to any authority investigating an offence committed prior to the commencement of the CRP. Nevertheless, what they shall do is they shall extend all assistance and cooperation to the authorities which are investigating the offence that were committed prior to the commencement of the CRP. Now what this section basically did was it provided a sort of immunity to the resolution applicants. Now what this immunity did was that the successful bidders or the successful resolution applicants, as is the word used under the code, when they get approval of the adjudicating authority or NCLT, then they are granted an immunity from investigations that are being conducted either by any investigating agency such as an enforcement directorate or the CBI or other bodies such as the Securities and Exchange Board of India, etc. Now, coming to the topic, the title. This section 32A is more commonly known as the clean slate theory. After going through the CRP, the management of the company is expected to begin with a clean slate, which essentially means that the business of the corporate debtor is revived again and is expected to start afresh under a new management. So the new management, when they take over the CD as a successful resolution applicant, they are expected to start afresh and run the CD or the corporate debtor as a going concern. Now, this new management, when it takes over that company, it cannot be riddled with frivolous, unwanted, old litigation that was associated with the earlier corporate debtor. These offences that happened prior to the commencement of the corporate insolvency resolution process. Now, why was this section introduced? The government wanted to provide incentives to investors who are known as resolution applicants to use their money and resources. Why did the government want to do that? The government wanted to instill a sense of confidence in these investors so that they can make investment of their money and resources without fear of persecution for offences committed prior to CRP. The government was also afraid that if the required amendment was not being made, then genuine, honest resolution applicants will not come forward to take up these distressed companies under the IBC. Now, who is this section 32A applicable to? Now, we'll discuss the applicability of section 32A. Section 32A is only applicable if there is an approved resolution plan. The resolution plan must firstly be approved by the requisite majority of the committee of creditors, and it must be approved by the adjudicating authority. Secondly, there must be a change in the management and control of the corporate debtor. So there has to be a change in the management and control of the corporate debtor. This was made so that Section 32A could not be misused by the erstwhile promoters and directors of the company to escape criminal liability when they were taking over the corporate debtor under corporate insolvency. The new management, it is understood that the new management cannot be a disguised avatar of the old management. And it is also understood that it could not even be a related party of the corporate debtor. So all these restrictions are inbuilt under Section 32A, that the new management which comes over and takes over the corporate debtor cannot come in the disguised avatar of the old management. It should not be a related party of the corporate debtor or the erstwhile promoters or directors. Now, what was the objective of introducing Section 32A? The basic and primary objective that was there for Section 32A was that the successful resolution applicants must be granted protection and immunity from any misdeeds of the past conduct of the corporate debtor, since they had nothing to do with it. Further, it held that such protection must also extend to the assets of the corporate debtor, which form a crucial part for potential bidders, which we call resolution applicants in this case, and help them in assessing and placing a fair bid for the company, which is known as a resolution plan, which in turn will help bank and other financial creditors clear up their books of bad loans. Now, in other words, what Section 32A does, it aims to detach all liability associated with the corporate debtor and their property and assets to prevent attachment or confiscation of the same. If this would not have been done, it would have defeated the entire object of the code, which was revival of the CD and maximization of value of the assets of the corporate debtor. Now, there are certain judicial precedents associated with this case. The Supreme Court of India is, along with the High Court, one of the Constitutional Court. So when this Section 32A was introduced in the Parliament and passed by making an amendment in the year 2019, its constitutional validity was challenged before the Honorable Supreme Court. The Honorable Supreme Court, in the case of Manish Kumar versus Union of India and others, it upheld the constitutional validity of the third provision of Section 7, Clause 1 and Section 32A of the Insolvency and Bankruptcy Code. The Supreme Court said that it was important for the IBC, which is the Insolvency and Bankruptcy Code, to attract bidders who would offer reasonable and fair value of the corporate debtor to ensure the timely completion of CRP. It further stated that the extinguishment of criminal liability of the corporate debtor is apparently important to the new management to make a clean break with the past and start on a clean slate. So the Supreme Court understood the rationale and objective with which the Section 32A was brought about by 2019 amendment in the code. It understood and stated that the criminal liability of the corporate debtor, which was there existing due to the past actions of the corporate debtor, needs to be extinguished. And apparently they understood that this was very important for the new management, which was taking control and management of the corporate debtor by submitting a resolution plan. The Supreme Court understood that if it is not there, potential bidders or successful resolution applicants will not come forward and offer a resolution plan to take over these distressed companies. It also stated that attaining public welfare very often needs delicate balancing of conflicting interest. As to what priority must be accorded to which interest must remain a legislative value judgment. So what they did was they understood that the legislative value judgment must be honored here, and they upheld the constitutional validity of Section 32A, looking into it. And if seemingly the legislature, in its pursuit of the greater good, which under 32A was granting immunity for past offences for the new and upcoming resolution applicants, appears to jettison the interest of some, it cannot, unless it strikingly ill squares with some constitutional mandate, suffer invalidation. These were the words which the Supreme Court stated that Section 32A is constitutionally valid, sound, and upheld it in its decision. Then there are certain other court decisions associated with this section. We have the Kolkata bench of the National Company Law Tribunal in the matter of Mr. Anil Goyal, who liquidator of Varsana Ispat Limited versus the Deputy Director, Director of Enforcement, held that the non-obstant provision of Section 32A is also applicable to liquidation proceedings. The National Company Law Tribunal held that not only CRPs, the Section 32A is also applicable to liquidation. Now, what is liquidation? Now, where a resolution fails, then a liquidation order is passed by the adjudicating authority and the liquidator is appointed. The basic purpose of the liquidator is to sell and auction the assets, both movable and immovable, of the corporate debtor and distribute the realizable amount amongst the claimants, which are the creditors, which could be the financial creditors and operational creditors of the corporate debtor. Hence, the National Company Law Tribunal held that the liquidator can proceed with the sale of the assets even if it is under attachment by the respondent. The NCLT held that even if a company is not under corporate insolvency, the company has gone into liquidation, where the corporate insolvency resolution process has failed and the adjudicating authority has passed an order for liquidation, a liquidator has been appointed. Now, the basic objective of a liquidator is to sell the assets of the corporate debtor, as discussed, and distribute the realized amount with the creditors. So, to do that, it was essential that the assets of the corporate debtor were available with the liquidator. So, it held that the respondent in the present matter, which was the Enforcement Directorate, cannot attach the properties of the corporate debtor, and the liquidator is to continue the time-bound process of liquidation. So, as discussed, the corporate insolvency resolution process and the liquidation process both are time-bound under the code. The corporate insolvency resolution process has to be completed in a period of 180 days, and an extension can be made on certain circumstances by the adjudicating authority by a period of 90 days, so the whole process is actually completed under 270 days, while the liquidation period has to be completed under 2 years. So this is a time-bound process of the code, and the government and the courts have understood that to respect this time-bound feature of the code, what is essentially needed is that the corporate debtor must not be riddled with various litigations when it is under CRP, as the moratorium provision suggests, and even after, when it is being taken over by the resolution applicant, wherein Section 32A protects the resolution applicant by giving it immunity for offences committed prior to CRP and even during CRP, wherein the cases have been initiated. Now, in the present matter, it asks the liquidator to continue the time-bound process of liquidation in terms of the provisions of the code, and it basically held that upon completion of the sale proceedings, the buyer can take appropriate steps to release the attachment. So the Enforcement Directorate had gone on to attach the properties of the corporate debtor. NCLT held that the buyer can take appropriate steps to get the release for the from the attachment of the Enforcement Directorate of the properties of the corporate debtor. It went on to held that the attachment and confiscation of properties of a corporate debtor undergoing CRP or liquidation automatically becomes void under Section 32A of the Insolvency and Bankruptcy Code. There were other judgments held. One of the famous judgments was Essar Steel India Limited. The Committee of Creditors of the Essar Steel India Limited versus Satish Kumar Gupta, in which the Honorable Supreme Court held and crystallized the green states theory by holding that a resolution applicant cannot be afterwards traumatized by surprising him with undecided claims and Hydra head popping up subsequently after the resolution plan has been accepted. So when the resolution applicant comes forward, gives a resolution plan, and has taken over the corporate debtor, then after taking over the corporate debtor, he cannot be riddled with these Hydra heads of previous litigation, undecided claims that were not present there before, and those offences that were committed prior to CRP must be extinguished. There was another case decided by this Honorable Supreme Court, Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited in the year 2021. The Honorable Supreme Court, while restraining statutory departments from recovering its dues after the approval of resolution plan, stated that once a resolution plan is approved by the adjudicating authority by using its powers under Section 31, then it is binding on all stakeholders, and no creditor, including government authorities, can initiate legal proceedings in respect of their claims or dues not provided for in the resolution plan. I would like to end the session by stating just one of the last cases, which is the Diwan Housing Finance Corporation Limited case versus Union of India. Diwan Housing Finance Corporation Limited was the first financial service provider admitted under CRP under the code. While dealing with an important issue, the court held that whether Section 32(1)(a) of IBC lays down a direction that CD would be absolved of all criminal offences committed prior to commencement of CRP from the date of resolution plan, although appeals against Section 31 were pending before NCLAT. The Bombay High Court held that the facts of the case, and in particular subsequent events, has indisputably established change in management of a corporate debtor. A new corporate resolution applicant had come forward and taken over DHFL in this case. So the DHFL stands discharged from the CBI special case number 830 of 2021 pending before the CBI cases Sessions Court, Mumbai. And it held that the accused directors of the corporate debtor, who were ousted from the board of directors by the RPI approximately 2 years ago, and and has since no control over the management. Accordingly, prosecution must not be initiated against them. Now, I would like to conclude by saying, what does Section 32A do? Section 32A gave the much needed confidence to resolution applicants to proceed with confidence when they were investing with their money and resources, and while they were making a bid or providing a resolution plan, as it is known, on disputed companies and their assets, the CDs which were under CARP. And with this spirit in mind and the larger interest of keeping a company as a going concern, value maximization and time-bound process of the code, the Supreme Court of India has also upheld its constitutionality in the code. And thank you. That's why.